Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is here. Thanks for joining me, everybody. I am here with Zach Morgan once again. How's it going?
Good, Aaron.
Awesome to have you with me to chat about this lawsuit, this civil lawsuit against Scientology, and to answer the question, to settle or not to settle, because this question is going to come up once David Miscavige, hopefully, is ruled to have been officially served in this case and that he is now a party to this case. I'm not saying that once he's served, they're going to try to settle right away, because I don't think that's true. There's many more hurdles to clear. But sooner than later, this question is going to come up. Settle or not to settle? And I want you to help me understand the right way to think about this and the pros and cons of either choice, because, you know, passion runs high in the Scientology world. And I know that there is definitely a perspective that people who have Scientology on the ropes should, you know, take it all the way and administer as much pain as possible, extract as much flesh as possible, go the distance, get a jury verdict, really stick it to them. And yet I personally am unclear on what stick it to them even means when we're talking about a civil trial. So help me understand some of this. Well, how should people be thinking about this? The pros and cons of settling versus going all the way to a jury verdict.
Sure. So first and foremost, the thing we have to understand is that the worst case scenario outcome of a lawsuit in which Scientology is a defendant, or any of their various names, I say Scientology, the greater entity, or the greatest possible outcome for a plaintiff in this case, in any case involving Scientology in a civil matter, is money damages. Nobody goes to jail. Worst case scenario, nobody goes to prison. This is not a criminal matter. So there is no conviction. There's just either a civil liability or no civil liability. It's money damages or no to money damages. That's the worst case or best case scenario for anybody involved. So then the question becomes, at some point, Scientology or its entities will likely offer a significant sum of money. When I say significant sum of money, I don't mean $500,000. I mean the kind of money that is generation changing. You know, 6, 7, 8 zeros, probably. And then the question then becomes, can I do better at trial? And oftentimes the answer is maybe. Depends on our jury, depends on our jurisdiction, depends on how well our witnesses present, not just the plaintiffs or the defendants, but the witnesses they call in support of their testimony, depends on the effectiveness of the lawyers. So lots of different issues. But the ultimate deciding factor is, what is it that the plaintiff wants? If the plaintiff just wants their money and to go away, I can write a big enough check. If my pockets are deep enough, I can write enough check. If the goal is to bring awareness to the wrongdoings of the church, the abuses of the church, all these issues, the labor trafficking and the various types of abuse and misdeeds happening in the church, I want a jury trial. I don't care if they give me $1. I want the testimony. I want all of that evidence that people can look up and see in the newspaper.
So let me ask you a follow-up question on that subject right there. What is the difference between so you said expose, what was the phraseology you used? If your goal is to
expose the wrongdoings.
Okay, expose the wrongdoings. What is the difference between exposing the wrongdoings on, say, YouTube, or exposing the wrongdoings in a court of law in the process of a civil case? Does one have more weight?
In my opinion, it absolutely does, because I can be an aggrieved party. I can be mad at my neighbor that they painted their fence purple. And I can get on YouTube to an audience of 100 million people and complain that my neighbor's fence is purple. That doesn't mean anything. If I go to court and a jury says it is unlawful to paint that fence purple, or it violates a covenant or a contractual obligation, I have an order that says what you did was wrong. Now it's not just me venting and being angry at somebody. Now I have a legal basis to say what you did was legally wrong, and the jury said so. Okay. And so it defeats the church's ability to say things like they say about you and Mike Rinder and Mark, of, oh, well, or even Leah, oh, they're mad. They left the church. They're not welcome anymore. They're just angry that they're out of the Scientology community. No,
Okay.
this is a court order that says what you did was wrong.
Okay, so when you say expose the wrongdoing, you're not just talking about sitting up there and giving testimony. You're talking about the impact of having a jury rule. We have found these people to be credible, and we are finding Scientology liable for damages. It's like putting an exclamation point on the exposure, not just the exposure itself.
Exactly. The other thing is, if you settle, there's obviously going to be a non-disclosure agreement. We call those NDAs. It means that you not only can you not say disparaging things, you can't say anything at all. You can't talk about it was settled. Also, when you sign an NDA and a settlement agreement, every settlement agreement I've ever drafted, especially working for the defense, it says that we are admitting no liability. However, we have decided, the parties, everybody has decided it's better if we write you a check to go away, you leave us alone. But we're not admitting that we did anything wrong.
Interesting. Okay, so for the moment, I'm going to take this out of the realm of the potential of what might happen in the lawsuit that's currently ongoing against David Miscavige for trafficking, underage kids on Scientology's Free Winds cruise ship. I want to talk for a moment about a civil lawsuit that was already settled years ago. And it was Laura DiCrescenzo, former Sea Org member, who as a Sea Org member, as a minor, was married, got pregnant, and was exposed to an incredible amount of harassment and duress and pressure to end the pregnancy so that she could continue to remain in the Sea Org. And she did not want to. And her auditing folders and her ethics folders and her personnel folders were just riddled with the evidence of how much pressure was being brought to bear upon her by officials in Scientology who had authority over her. The crux of this lawsuit wasn't that this occurred, because that was actually pretty common in Scientology. It was that it was occurring while she was still a minor. That's actually what made this particular suit have teeth, a lot of teeth. Okay. Scientology managed to delay the process from the point when the lawsuit was filed to the point when they were actually scheduled to start the trial for 9 years. But after 9 years, Laura managed to clear all of the hurdles, by the way, including the arbitration clause hurdles and everything like that. And they were scheduled for trial. The day before trial started, Scientology settled for what I believe to be an amount. Scientology's goal was, we're going to settle for an amount that you'd be insane not to settle for, right? Like, that's their strategy. At that point, their goal is to settle at all costs. At that point, to Scientology, money's not an object. Their goal was, we will literally pay anything to stay out of the courtroom. What do you make of that?
So it certainly puts the attorneys in an interesting position, because on cases like that, attorneys take it on a contingency fee, right? You see it all the time on, have you been injured by a crazy truck driver? Do you ride motorcycle and got rear-ended by a mama in a minivan? You see it all the time. I don't get paid if you don't get paid. But when you win, I get a percentage of what you win. In most states, not to exceed 50%. And it's often staggered based on how far we go. The sums of money we're talking about are generational wealth changing types of money. And so it's really hard for a lawyer to say, don't take this deal, especially when you run the risk of getting an adverse verdict at jury trial. But the client has every right to say, I'm not going to settle this. I'm going to get my day in court. If the jury believes me, the jury believes me. If they don't, they don't. But I'm going to sleep better knowing I exhausted every revenue or every resource and every avenue available to try and get this to a conclusion that is helpful to me. And so as the attorney, that is where we have to focus on our ethical obligation to our client. Because what is in my best interest is the fact that I can make payroll for the next decade off of my 35 or 36%. But what's important to you is that, dadgummit, I want to get in front of a jury and a judge, and I want to make them ask me questions. And more importantly, I want to put them or their designated representatives in that box, and I want to ask those people questions.
Right. Does the fact that, well, if you put yourselves in the plaintiff's shoes, and let's say you're sitting over there and you've got a high confidence level, you have Scientology over a barrel, so much over a barrel, they're willing to pay you anything right now. And yet for just a few more weeks of trouble, you could not only have them over that same barrel, but not be gagged, have all the evidence out there in the public. help me understand what's actually at risk. What is the plaintiff risking by moving forward?
They're risking a jury verdict where the jury comes back and says, we don't believe you proved your case, so we find in favor of the defendant, so you get no money. Or I've actually had this happen to me. The jury says, hey, we agree your client was injured or this bad thing happened, but your client gets $1 or your client gets no money at all. And as the law firm, if I'm representing the plaintiff in that case, I have fronted the expenses. I've paid several $100,000. So let me take a step back. Here's a classic case happened to a friend of mine who's a mediator now. He's about half retired. He represented owners of a luxury car in a class action lawsuit involving airbags. This predates the Takata airbag thing with Toyotas. He bought a $100,000 luxury car, sent it down to a testing company who did a crash test on it. He paid him $25,000. Came back and his expert said, hey, they didn't do it right. We have to do it again. So we had to go buy another $100,000 luxury car, pay another $25,000. He's $250,000 in just to generate the evidence to go to trial. If he loses, his client is not on the hook for that $250,000. The attorney has to eat that. And for a lot of lawyers, $250,000 is 6 months of payroll or more.
Interesting. So I think it's easy for people in my world, the former Scientology world, former Sea Org members, second generation members, to think that that because we know the things being litigated here really occurred, because we know the evidence exists, because we know how Scientology covers things up, I think it's easy for people in my world to go, these cases, once you get in, oh, it's a slam dunk. It's just a slam dunk. Because also I've said on my channel many times, Scientology has never in its history won a jury trial, not criminal, not civil. It's never won a jury trial before, which is one of the reasons they will pay anything to settle a trial once they know they have no choice but to go to trial. What do you think about that?
So what I will say to that is this, and I know that there were some standards, so some different burdens of proof in the Danny Masterson case. There were lots of people who said, man, this is a slam dunk case. He's going to go to prison. And now we have to try the whole thing all over again. There's just now, like I said, there's a lot of other issues that you have explored and some other journalists and stuff have discussed. And there's a lot of information out there on it. But, just one of those things that there's a lot of questions. You may have a great witness who shows up and has a bad day on the stand. This predates you, it predates me, it predates probably most of your viewers. But one of the reasons John Kennedy won the presidential election in 1960 is because he had the first televised debate with Richard Nixon. Richard Nixon had the flu and was sweaty and disgusting looking and generally looked unpleasant because he was ill. And Kennedy presented well, and everybody said, oh, this guy's posed and charismatic. He's the man for the job. Ultimately, we know Nixon comes back and wins several years later. But that's an intangible. Statistically, Nixon should have won that. He was Eisenhower's VP. But he just had a really bad day when the lights and cameras were on.
So it really does come down to what is the motive, what is the goal? What was the plaintiff's goal of the lawsuit when they first filed? I don't think anyone involved in any of these lawsuits both past, present, and future, started the lawsuits just thinking, boy, I'd like to get some money from Scientology. I mean, it's an awful lot of hassle and trouble to go through just for some dollars. And I just don't believe that was the motivation. And I don't believe it is the motivation. But does it just come to be that once someone offers you a settlement that you'd like, really, Scientology's goal is we're going to offer you a figure you can't say no to. How much pressure can the attorneys bring to bear to be like, look, like, would the attorney actually sit the client down and try to pitch them on taking a settlement? Or is it one of these things where once the client expresses their wishes, the attorney's like, required
so
to
the attorney's obligation is to sit down and explain to the client, here's the offer we've received. It's a finite amount of money. Here's how much I get. Here's how much you get. Here's how the bills get paid. If you choose not to accept it, and that is your right, the next step would be trial. Here's how much it's going to cost. Here's how long it's going to take. if, I can give you a statistical probability of, it's 60-40 we win lose, it's 75-25, it's 50-50. I can tell you how much damages tend to go for in this jurisdiction or in this county or in this district or whatever. And we can look at what the statistics tell us, but ultimately it's the client's decision. If the client, theoretically, if the client decides to go to trial, but the attorney says, I recommend you settle, and the client goes against the attorney's advice, the attorney can fire the client, just like the client can fire the attorney. It's a mutual relationship.
Wow. What happens if the jury comes back with a verdict of damages or punitive or whatever that's less than the original settlement offer? Does that trigger anything?
No, the settlement by law in every jurisdiction, to my knowledge, and as a matter of public policy, every settlement offer, no settlement offer is admissible at trial.
Right. I understand that.
Right. Yeah. So the fact that the settlement offer was less than, or the jury verdict was less than the settlement offer, something has absolutely no bearing, generally speaking.
On anything?
No.
Okay.
I mean, they may have offered me $10 million. The jury gives me $1. I get $1.
So if Scientology offers to settle, the clients, the plaintiffs, they can counter with anything, right? Like the plaintiff could say, we'll take that financial settlement, but no gag order, right? They could have. Yeah. I mean, they could.
Yeah, they could say that, yeah, I'll accept the money, but as a term of the settlement, I'm not signing an NDA. I'm not signing a silence agreement. In fact, I'm reserving the right specifically to, publish it in newspapers or do an interview with 60 Minutes or do an interview with Aaron or whoever. Now, if I'm on the other side of the coin, I'm going to, on the other side of the coin, if I'm advising the defendant, like, listen, we're not going to accept any settlement that doesn't include an absolute NDA. We'll pay you $10 million today for an NDA, or if you don't want the NDA, we'll go to trial. But a term of our settlement is, and in that case, it's just a contract that we couldn't agree to the terms on.
Right.
But neither one of those offers, the $10 million or the NDA, neither one of those are admissible to the jury.
Right. So I'm trying to put myself in Scientology's shoes, David Miscavige's shoes, and think if there's anything other than just simply bad PR. Is there anything else that I'm trying to avoid by settling? So a specific question here would be, is there something binding or precedent setting about a jury in a civil trial ruling that we'll take the trafficking case that's currently ongoing? Is there anything binding or precedent setting if a jury were to rule what these people experienced in the Sea organization as minors, we find rises to trafficking and
Sure.
damages are X, Y, and Z? Or is it just that just happens to be a ruling that was made in that case and there's no precedent in the civil world? Like, so, I don't know how it works.
Sure. So I think that's a fair question. I see this in the comments a lot. Well, would settling set a precedent? Would this set a precedent? Would that set a precedent? The answer is always no. Absolutely not. And here's why. The term precedent, meaning I am bound by a different court's decision, precedent can only be determined by a higher court. And so, for example, and I'm not getting into the politics of it, but for example, Roe versus Wade was recently overturned. Prior to that, we had 40 years of precedent that, states could restrict this, states could do certain things to manipulate access to rights, but they couldn't completely ban it because the Supreme Court said it's a fundamental right. And then a later opinion came out and it changed when those rights began and when they ended and that sort of thing. But it's an absolute fundamental right. Now, that's been flipped on its head because of the new opinion. But until there was precedent, each district court could sort of do whatever they wanted. And so precedent is only binding on those courts, on those lower courts, as those rulings are handed down by courts of appeal. Precedent is created by courts of appeal. The fact that the judge in Tampa did such and such on this case doesn't mean that his or her neighbor in the same courthouse down the hall has to do the same thing on the same case in 5 years.
Interesting. So it's not like if the plaintiffs in this current trafficking case saw it all the way to the end and there was a jury trial verdict against Scientology, it would open up the floodgates. Or would it? Like, am I conflating things? Like, I'm thinking that if you set a precedent, it opens up the floodgates, and if you don't, it doesn't really change the landscape.
So, I think it's one of those. I think it goes either way. there's no legal precedent to it, but if this goes to jury trial and they get a great verdict, it's going to open the floodgates for all former Scientology members to try and file suit there and get a successful verdict. But the converse is true as well. If they don't win, it's going to give any attorney hesitation before they file the suit and go through the expense and the inconvenience, because it's not just expensive in terms of money. It's also expensive in terms of finite resources. There's only so many hours a day to work. There's only so many cases the firm can take at a time. There's only so many paralegals. There's only so many pleadings that can be filed. Like, it's also taxing on other finite resources other than just cash.
Right. So I think Scientology, the reason they will pay anything to settle once they know they don't have a choice but to go to trial is for a few of these reasons. I think they know a jury trial. I think they know they've never won a jury trial, and a jury trial is not likely to look sympathetically upon them. Scientology knows the evidence for these things occurred. So not only did these things occur, but the evidence is in all of the files. So they know the evidence is against them. They know they've never won a trial before. They don't want all this testimony in open court. They don't want what I'll call the precedent of just having a verdict against them. It would open up the floodgates for similar things. Mm-hmm. And for all those reasons, they are going to make a settlement offer that is almost impossible to say no to.
Absolutely. The biggest thing, so notwithstanding the fact that David Miscavige and whoever else will be subject to deposition, the big thing they're trying to avoid, because they always say, well, this doesn't exist, it's simply not true, we don't have these records, they're subject to subpoena power. Hmm. By virtue of filing a lawsuit as an officer of the court, as soon as I have a pending lawsuit, I have subpoena power. I can issue a subpoena. And you can try and fight it. You can try and quash it. You can try and narrow it. There's a lot of things that you can try to do. But that subpoena power is impressive. I can not only can I get the documents you have in house, but I can contact where you bank. I can get your bank records. I can get the credit card records of members. Mm. I can get cell phone records, assuming, because it's a bunch of paranoid crazies, that let's say they put GPS trackers on all of Scientology-owned vehicles. I can subpoena the data tracking to show where David Miscavige goes and the vehicles he drives and the routes he takes and the places he lays down and lays his head at night. I can access it's an infinite amount of information I have access to through the power of a subpoena.
Wow. Wow. So again, I try to fight the urge to oversimplify things, but here's an oversimplification. I put myself in the plaintiff's shoes. These guys already have massive guts for filing the lawsuit. These people are not intimidated. These people are not scared. They're also not greedy. And so, I know these people. And I put myself in their shoes and I go, we've already gone through hell. Scientology's terrified of what's about to unfold. By the way, in this example, we're on the verge of going into court like tomorrow.
Yeah, sure. Yeah.
Trial.
Yeah, we've got jury selection starting tomorrow morning. Yeah.
Yeah, they're terrified. They're on the ropes. They're begging to settle. In 2 or 3 more weeks, we'll probably be able to extract even the jury's almost guaranteed. I say almost guaranteed. This is my oversimplification, right?
Well, of course.
The jury's guaranteed to come back with damages far in excess of what Scientology is trying to settle for now. Plus, we won't be gagged. Plus, we're going to embarrass the shit out of them in open court. Plus, it'll open up the floodgates to other stuff. I kind of go, what do we have to lose? Let's go forward. But that's where I go, but what are they risking? And I know you've already answered that question. But right. I can't help but come back to my oversimplified version because that's the version everybody would like to see.
Sure. So, so here's a really good, because we've seen this. Here's a really good version of that. And I've used this example before because most people have heard of it. It's not an attack on the Catholic Church. It's just the reality of it. The Catholic Church has been doing this for 100 years. A priest misbehaves. The priest may or may not be punished by the diocese or archdiocese. It doesn't matter. Victim files suit. Or prior to victim filing suit, church reaches out and says, we're going to give you life-changing money to shut your mouth and go away peacefully. Right? And the single wealthiest private entity in the world is the Roman Catholic Church. I mean, they've got, frescoes by famous artists all over the roofs of their buildings. Like, it's not, they've got more money, more cash than anybody else on the planet, other than like governments and stuff. Especially when you're Congress and just write blank checks. But they've been doing this for hundreds of years, just settling by giving you enormous sums of money to shut your mouth and go away quietly. And they're perfectly satisfied with that. But then when you started to see like the Boston newspaper, the Spotlight series, right? Some of these people breached NDAs because they felt it was so important the public know about it. They breached non-disclosure agreements. Now, if I breach a non-disclosure agreement, the worst case scenario is I have to pay that money back. I may not have it. Cool. I go file bankruptcy. No harm, no foul. So I'm not saying abuse the bankruptcy system because that would theoretically be fraud in bankruptcy. But if I settle and then later change my mind and say, I can't live with myself, I have to make this public, worst case scenario, then I have to give them their money back. But I'm not going to go to jail for breaching an NDA.
So in a world where things are easy to predict and things are relatively black and white, you might say if the plaintiffs had an extremely high confidence level that the jury verdict would go their way, then it would make sense to move forward. But if you don't, you're rolling the dice.
That's essentially it. Yeah. You calculate what's more important. And you know what? Sometimes even if you lose rolling the dice, that testimony's out there. Even if you lose, even if you don't get the verdict you want, maybe it gives another victim somewhere strength to say, if they can do it, I can do it too. And even if I lose this one and I lose that one and I lose that one, I'm eventually going to get the right mix of a good jury, good witnesses, great lawyers, and we're going to have a field day.
Right. I know people will point to the disappointing result of the Danny Masterson trial as like sort of a cautionary tale. But boy, I'll tell you, there is a world of a difference between having to prove a criminal matter beyond a reasonable doubt and having to prove a civil matter by preponderance. Is it preponderance of the evidence?
It is. Yep.
And the stuff that is at issue in the labor trafficking case against Scientology, I don't want to, again, I don't want to make the mistake of talking about it all just too simplistically, but
well, sure.
It's much easier to prove, I think, in the eyes of a jury. I think it's a completely different ballgame than what is occurring in the Masterson trial, or did occur with the last jury, I should say. There's just something to be said about Scientology never having lost a jury trial. And realize Danny Masterson isn't Scientology. He's a person. Scientology is relating to that case, but it's not on trial in that case. Scientology's never lost a jury trial. And that was back when people didn't know as much about Scientology as they do now. Now, like, everybody knows about Scientology, and not in a good way.
No, I hear you.
So Scientology, this must be absolutely terrified of these three people finally getting their day in court.
There's definitely there's not a lot of sleep going on at the executive offices for sure.
Is there anything else that factors into whether to go to trial or not that we haven't touched on that would be valuable to discuss?
No, those are the high points. I mean, there's an infinite number of little minute things, but those things tend to pop up throughout the case. There's no blanket on what fits, but the big one is really, what is the ultimate outcome sought by the plaintiff? Is it a huge money award? Because otherwise I can settle that. But if it's awareness, then we're going to put 12 in the box and roll the dice and see what happens.
Right. You talk about some of those precedent setting things. I know there are other trials, other potential cases, I should say, just standing by waiting to see if these three plaintiffs are going to be allowed by the court to go to trial instead of being forced into arbitration. There's other cases where the lawyers are like, we don't want to move forward if all of these other guys are just being thrown into arbitration, because our goal isn't to get thrown into arbitration. We wouldn't move forward. Being thrown into arbitration with Scientology is a lose-lose situation. It's the deck is stacked. There's no point. And so if this labor trafficking case does move to the point where if the court does rule that their arbitration agreements were signed under duress and they are permitted to move forward in the court system, that is going to open the door to a handful of other lawsuits that are just waiting in the wings, So that's pretty exciting. Hey, what's that little guy behind you there?
This is my mini mic. I brought my mini mic. So go spshop.com, I believe. Get your mini mics and let him sit in and attend all your meetings like he does mine.
That's funny. You've got a miniature Mike Rinder, but I've got a life-size David Miscavige doll right here. Oh, we have fun. We have fun. All right, everybody. Actually, you know what? Let me jump. Help me answer some of these super chats here. Okay, Jaded Slave says, how many Hell Zenus do you get for hiding all the apple boxes? Love and support for AA Run and all the heroes fighting against these monsters. Thank you very much. That'll be 3 Hell Zenus. Thank you very much. Okay, let's see. I did see a few more. Oh, by the way, everybody, we will be doing Mondays with Mike and Mark at 7 p.m. Eastern. We're going to be having a lot of fun tonight. Hang out with me. Support whatever brings victims less stress and pain. Absolutely, 100%. 100%. The thing, it's funny because Scientology puts you through all the hell and the pain trying to get into the courtroom. Yeah. Once you get into the courtroom, they're the ones getting smacked down in a very major way. So, okay, Pat Shore. Hey, Ron, got a foot of snow up here in Maine and still snowing. You want us to send some down to you? Oh, please do. I grew up in snowy, I grew up in the Northeast, so I see snow all the time. My girls have grown up without snow, but they've gotten a taste of it. We've taken them to Colorado to see snow. We've taken them to Montana to see snow. And they've been begging, can we please go see some snow this year? But
that's that good Rocky Mountain snow.
Yeah, exactly. But yeah, no, we actually have perfect weather right now. It's like 60s. I mean, it's just absolutely amazing. Okay, we got one here from Brian S. Settle if DM's deposition is made public. I suspect this is why David Miscavige, if he actually, if rulings go the way we want them to go so that he can be deposed, I'm guessing they may try to settle to preempt David Miscavige being deposed, and that would actually fast track a settlement in this case, as opposed to dragging it out years and years and years.
Yeah, absolutely. They're not. If they would never, I don't think they would entertain settlement options after his deposition is taken, because they've lost all the leverage. So as soon as his deposition is taken, you can still settle. There's nothing stopping you, but absolutely, there's no way they would entertain a settlement at that point.
Very interesting. Okay. There is more, but my mouse is being very glitchy, so bear with me, guys. Okay, here we go. Kevin, love the deep dives. Isn't trial risky? Because even if you win, the resources of the Scientology, the resources of the Church of Scientology will appeal and lock that money up for years and more. I'm glad you asked that, because I meant to ask that earlier and I totally forgot. Even after a jury verdict comes back, could Scientology tie it up for years after that?
Probably not years. In civil matters, in most jurisdictions, you're only guaranteed one initial right to appeal. In criminal matters, there's additional levels of rights depending on whether or not you get the death sentence after a conviction. So years, plural, probably, but we're not talking decades. We're talking 2 or 3 years. Like if it would go to, like in Oklahoma, if I appeal a case today, it'll be decided by the end of the calendar year. Because the court can change personnel, and if judges or justices leave an appellate court, they would have to re-argue it. So most of the time, in fact, in the state of Minnesota, certain types of appeals are limited to 90 days. After oral argument, the panel has to release their opinion within 90 days. So years, yes, but we're not talking decades. We're talking 18 months to years, probably.
Very interesting. Elizabeth Stowell, arbitration agreements are canceled upon declaration on suppressive person according to declare notice. So there. Okay. So she is referring to something that was mentioned in one of Mark Headley's videos, and I think I did a commentary on it, where in the issue that declares Claire Headley a suppressive person, it actually says any agreements she has signed with any Scientology organizations are null and void. And Scientology really uses whatever language it wants to use. Those suppressive person declares are not legal documents, but it is their own document. And it would stand to reason that their own document nullified the binding nature of the arbitration agreements that Claire Headley had signed. I don't know how a court would interpret it, but it's funny to consider that they might be invalidating their own agreements.
Yeah, it is. I agree. The other problem is very rarely are they actually issuing suppressive or SP notices anymore. Most of the time, they're just told, their families are told, so and so's an SP. You can't congregate with them anymore. They're getting smarter, not putting as much in writing.
Exactly. All right, everyone. Well, those are all the chats, and thanks for hanging in with us here. Again, we are doing Mondays with Mark and Mike tonight at 7 p.m. Eastern. So tune in for that. All right, everyone. Talk to you later.
Balake. Where is Balake at?
My name's Blake.
Do you want to go to
That was the wrong one. Here we go.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.